We're figuring it out. This briefing is being streamed on the Maryland General Assembly YouTube channel. Members' microphones will be muted throughout this briefing. If you have a question after the presentation, please press the button on your microphone. After I call your name, please wait a moment while staff turns on the microphone. Remember, our usual committee rules are one question and one answer from the panel, not one question and one answer from each individual panelist. Also, please keep your questions brief. Please keep in mind that this briefing is scheduled to conclude at 3 p.m., but be a little bit flexible if it takes a few more minutes after that. Today, the Health and Government Operations Committee will be hearing from the Open Meetings Compliance Board, the Public Access Ombudsman, the Public Information Act Compliance Board, and the Maryland Commission on Civil Rights. Today, our wonderful lawyer for the committee is Ms. Lindsay Lohan. Thank you. And she is our expert on government operations, on all these issues that we're going to be discussing today. So she advises the committee. Our first panel will be virtual. We will begin actually with the Assistant Attorney General Rachel Simonson, representing the Open Meetings Compliance Board, and she will actually bring up the presentation. And bear with us because we have to let her in. There she is. Good afternoon. How are you?
Good afternoon, Madam Chair. I'm very well. Thanks for having me.
This is our first hearing where we have someone virtual, and I know the way it's going to work for the committee is that you will give your testimony, right, your presentation, and then the committee will be able to ask you questions. When you're finished, you leave, and then we allow the next person in. And then when we're done with the virtual testimony, then we go to the live testimony, okay? We'll get this right. So we're all yours.
Thank you, and thank you for the accommodation to be able to testify remotely today. I very much appreciate it.
Our pleasure.
My name is Rachel Simonson. I'm an Assistant Attorney General, and I serve as counsel to the Open Meetings Compliance Board. And today, I want to provide you a brief overview of what the Compliance Board is and the work that it does. So the Compliance Board is an independent body. It is made up of 3 members who are appointed by the governor. They don't receive any compensation. There's no budget or staff appropriated for the Compliance Board. The Office of the Attorney General provides counsel and administrative support, but the Compliance Board is not part of the Office of the Attorney General. It is an independent body. The Open Meetings Act, which establishes the Compliance Board, requires that at least one member be an attorney that's admitted to the Maryland Bar. But in recent history, we've actually had several members serving simultaneously who are attorneys. And our current board, which is made up of 2 members. We have 1 vacancy. Both members are lawyers admitted to practice in Maryland. So the Compliance Board serves 3 main functions. The first function, which takes up the overwhelming majority of the Compliance Board's time, is issuing advisory opinions about the meaning of the Open Meetings Act and its requirements. When the Act was first enacted, there was no provision establishing the Compliance Board. But it became clear that public bodies could really use some guidance in how to comply with the Act. So in 1991, the General Assembly amended the Act to establish the Compliance Board to provide that guidance. The way that the Compliance Board provides guidance is through an informal complaint process. Anyone can file a complaint that a public body has violated the Open Meetings Act. Under the Act, a complaint has only 3 requirements: that it state what the alleged violation is, the date of the alleged violation, and that the complaint be signed. So the Act does not allow anonymous complaints. Once the Compliance Board has received a complaint, it forwards the complaint to the body alleged to have violated the Act, and that body is required by the statute to respond to the allegations. The complainant then has an opportunity to file a rebuttal if the complainant wishes, and if there is a rebuttal, the Compliance Board gives the body the final word. And once the Compliance Board has received all of the written submissions, the Compliance Board usually issues its advisory opinion within 30 days. Now, the process is different from circuit court proceedings. There's no burden of proof. The Compliance Board is not a fact-finding tribunal. If the compliance board has questions that are not answered in the submissions, the compliance board can have an informal conference, but it doesn't have subpoena powers. It can't compel witnesses to appear. It's not set up to take testimony. And so the overwhelming majority of complaints are resolved on the written submissions. Now, as to the opinions, these are advisory only. The Open Meetings Act is very clear about that. The opinions say either the board believes that a violation occurred, a violation did not occur, or there's not enough information for the compliance board to reach a conclusion. If the compliance board finds a violation, the Open Meetings Act requires that the public body announce the fact that the compliance board found a violation at its next open meeting. It has to summarize the opinion and it has to sign a copy of the opinion. But the Open Meetings Act expressly provides that by doing these things, a public body isn't admitting a violation. The compliance board doesn't have any power to compel compliance with the act. It doesn't sanction public bodies. It can't undo a legislative act that may have been enacted during a meeting that didn't comply with the Open Meetings Act. For any of those kinds of actions, someone would have to go to a circuit court. But what the compliance board does is provide guidance. Now, a public body is free to accept or ignore the guidance that the compliance board provides, because again, the compliance board can't compel a public body to change its practices with respect to meetings. The compliance board typically issues between 30 and 50 advisory opinions each year. Last fiscal year, the compliance board issued 48 opinions, which was the most that the board had issued since at least 2013. And the compliance board found violations in 25 of those opinions. I think that the high number of opinions is largely attributable to the pandemic. In the last 2 years or so, there have been a lot more complaints that are alleging violations based on practices that public bodies have adopted in light of the pandemic. You know, a lot more virtual meetings are happening, and sometimes complainants are alleging violations based on the fact that they are required to observe a meeting virtually as opposed to being there in person, or that, you know, a public body is limiting the number of people who can be in a space in person. But as I think we return a little bit more to normal, some of those kinds of complaints will probably taper off. This fiscal year, the compliance board has issued 21 opinions so far. The second function that the compliance board performs is issuing an annual report. This is required by the Open Meetings Act. It has to be issued on or before October 1st every year. And the annual report summarizes the activities of the Open Meeting Compliance Board. It summarizes the opinions and the violations that the Compliance Board found. And it specifically highlights the number of complaints that the Compliance Board received that a public body failed to give reasonable advance notice of a meeting. That's something in particular that the Open Meetings Act requires the Compliance Board to highlight in its annual report. The annual report is also an opportunity for the Compliance Board to make recommendations on changes to the Open Meetings Act, although the board has not made any recommendations in the past few years. And then the third main function that the Compliance Board serves is providing input on proposed legislation. So if there is a proposed amendment to the Open Meetings Act, sometimes the Compliance Board will have a special meeting to discuss whether to take a position on the proposed legislation or offer any sort of letter of information to lawmakers. So those are the three main functions: providing advisory opinions, issuing an annual report, and providing feedback on legislation. And if anyone has any questions about the Compliance Board, I'm happy to answer them.
Thank you. And for the committee, most of these bills that we discussed today are actually assigned to government operations, which Delegate Kerr is the new chairman of it. And then Attorney Rowe, she actually advises her on those bills, okay? That's what Lindsay does. So are there any questions for this witness? We have Delegate Kaiser. Thank you.
Thank you, Madam Chair. I'm just looking at my notes here. As I'm listening to this and the number of staff that you have and not being able to compel state agencies, is there any evidence of fewer violations over time? And I guess if not, kind of a two-part question, but if not fewer violations, are other states doing something in a way that has helped that fix the problem over time? Thank you.
I don't know if the number of violations have changed over time because the number of complaints, well, first of all, the Compliance Board, of course, can only opine on the issues that are brought before it. So it's largely dependent on the number of complaints that are received. And that varies from year to year. So I can't really speak to whether the overall number of violations of the Act has diminished or gone up or stayed the same. And I don't candidly know what other states do in terms of enforcement mechanisms. I don't know if they have similar boards that have powers to compel witnesses or subpoena. My understanding, though, is the way that this body has been established is to provide advisory opinions and not to be, an investigatory body. So I'm sorry, I don't think that really answers your question, but if you'd like us to follow up, I can certainly try and answer more specific questions, but I just don't have the information at my fingertips to be able to answer your question right now.
Will you be so kind and provide the information to the entire committee? You can get the answer, please.
Absolutely. So if I could just clarify the question, is the question, what do other states do in terms of similarly constituted bodies and what powers they have?
Thank you, Madam Chair. Yes, that would captures the question, but also more so, have any of them done the piece to compel and really try to reduce the instances of this? Because I feel like there's some groups that keep violating, so I'd like to think if there was more compelling or more penalty of some sort, maybe in other states, maybe they would see those declines. Thank you.
Okay, so I'm sorry, just to make sure I understand. So you would want to know information about what other states do in terms of the powers of a compliance board-like entity to both compel testimony and information, but also impose sanctions, it sounds like?
Yes.
Okay.
And thank you for taking the time to make sure that is the intent. We appreciate it. Are there any further questions from the committee, from any of the other members? Seeing none, thank you so much for being with us today, and I'm going to thank you in advance for providing that information. Thank you.
Sure thing. Happy to be here. Thank you very much.
Our pleasure. Next witness. Now you can see why we discouraging, we want people to come in, right? Because it's going to take a while as we start the work, but it's important for people to have access at home. Just Good afternoon.
Good afternoon, Madam Chair. It's a pleasure to be before your committee again today. I'd like to echo Ms. Simonson's thanks for allowing us to appear remotely. It is truly appreciated.
Our pleasure.
Thanks again. I know that many members of this committee are very familiar with the Ombudsman program, that is the Public Information Act Ombudsman program. I'm going to just call it the Ombuds program for short because it's otherwise a mouthful, but perhaps not everyone. And so I think so that we can all share the same context, I want to do a brief thumbnail of kind of the history and operations of this very young program. We were created by the legislature in 2015. I was appointed by the Attorney General as the first ombudsman. We opened doors for the first time in late March of 2016. And I am currently serving my second term. I'm in the middle of my second term as the public access ombudsman. Our central role is to try to facilitate resolutions of disputes that come up between people seeking access to public records and agencies that are responding to those requests. This is, in Maryland, we have a process that is not identical to, but is largely analogous to the federal FOIA Act and proceeds largely in the form of a written correspondence or email by way of request for records. When disputes come up, prior to the creation of my office, requesters had little in the way of actual remedies other than to go to court. But in 2015, the legislature created two distinct dispute resolution programs under the act itself, one being my program, which functions as a mediation program, and the other being the PIA Compliance Board. Counsel for the board is going to present shortly and can fill you in on the details of how they work. But in general, my role is not to enforce the act. I make no decisions and I can't compel anyone to do anything. Rather, I proceed by a process that's very akin to traditional mediations through one-on-one conferences with people, sometimes through group meetings, which we've been doing largely remotely during the pandemic, in order to explore options, alternatives, sometimes compromises, to try to find a path forward that will be acceptable to both the agency and the requester. The hallmarks of my program, I think, is distinct from enforcement programs, is that one, it's entirely voluntary. No one needs to come to mediation. Two, it is a very confidential process. I'm not allowed to talk about any information I acquire during mediation, and the parties themselves are encouraged to abide by the same standards. It is very informal. We work very hard to be user-friendly to all program users. And we have the luxury of being able to be as flexible as the parties need us to be within the parameters of the law. There are no limitations on the types of issues under the Public Information Act that I can deal with. And I regularly deal with all manner of issues, everything from problems with obtaining a response from an agency, late responses, denials of access, fees that are being assessed by an agency for access, questions about whether an agency's search for records was adequate or thorough. Sometimes I get interpretive questions such as, what does this response mean? And so really my work with parties runs the gamut of all the potential glitches and problems and miscommunications that can come up under the Public Information Act. The way my office is constituted under the statute, I am housed within and supported by the Office of the Attorney General, but not a part of it. Rather, I sometimes describe myself as being a live-in client of the agency, and I am supported by two truly outstanding staff of the Attorney General's office. One is an Assistant Attorney General, Sarah Clem, who will be appearing shortly to talk about her work with the board, but she actually serves both programs, both the board and my office. And we are also supported by an equally outstanding program administrator, Spencer Dove, with whom I tell you I would be truly lost in this work without. This program would never have gotten off the ground or been able to work with as many people as we have without their very able help and their dedication. Very briefly, I would just like to mention that apart from our mediation activities, we regularly engage in a lot of other activities that are really aimed at trying to prevent disputes or to nip them in the bud if we can. And these include things like preparing written training materials, educational materials about the Act. We give trainings on request to both requester groups as well as agencies. We receive a steady stream of what we call help desk matters. These are usually unilateral consultations, most often with agencies who have spotted a problem or an issue and they want to bat around some options or ideas. And it's a very informal process. Most recently, last year, we had a very intensive outreach campaign to make sure that all our program users were aware of changes that went into effect under the Act with respect to both my program and the board as of July 1st. In the materials I provided the committee, there are some examples of this outreach material, including some one-page summaries about the mediation process itself, as well as a one-page summary about what changed as of July 1, 2022. At the moment, we are also working on updating the Ombudsman's interpretive regulations to conform to the changes that were made to our program under House Bill 183, which, as I mentioned, went into effect this past summer. I will look back at the end and talk a little bit more about those changes and what they've meant to our program so far during the first 6 months of implementation. Let me also mention that in the materials we provided to the committee, these are attached as an appendix actually to the Public Information Act Compliance Board annual report. The board is required to submit an annual report. The Ombudsman, by contrast, has no mandatory reporting requirements and has no ready platform per se to publish data about the program. However, the board chair has every year invited my office to submit written comments about our work, and we do that every year. So the committee has my very brief narrative report accompanied by some very colorful statistical reports that our administrator puts together that reflect a lot of the details of our program operations and metrics. It also contains the one-pagers I mentioned that were part of our outreach effort last year. Let me talk a little bit about the program users. Many of these are your constituents. And so to the extent you have an opportunity to refer any of your folks our way, we certainly do welcome that. Mediations can be initiated by either agencies or requesters, but most often they are initiated by requesters. And of these requesters, a significant majority of them are individual citizens who have made a record request to an agency, either state or local, that is motivated by some interaction with the agency or some decision an agency has made that is impacting them, or in some cases, some inaction that is affecting them. In short, they are direct consumers and of state and local government services and programs, and their requests are typically focused on those interactions. At the same time, we get a steady stream of requests that come in to us from individuals as well as organizations that we refer to as occupational users. So these include, by way of example, media representatives, attorneys making requests on behalf of clients, businesses, private businesses seeking to do business with state or local government, or who are in need of other information about government operations. We get requests from independent researchers here in Maryland and across the country who are in need of government records and data for various projects that they work on. We have many requests come to us from nonprofit advocacy organizations who are seeking government data for their own advocacy purposes. And so we work with a very, very wide range and diverse group of requesters. On the agency side, we are working with state and local executive branch agencies at every level across the state, as well as the legislative bodies when requests are made to individual legislators or to county councils or the city council or things of that nature. Historically, our caseload has been roughly evenly divided as between involving state and local agencies. We saw somewhat of an uptick during the pandemic with a focus on state agencies. And my speculation is that that may have had something to do with the fact that the state was leading so many aspects of the response to the pandemic, and this was a matter of concern and intense public interest. In 2022, as we've detailed in our reports, we saw a very noticeable uptick in requests for assistance that involve record requests made to first responders, principally police departments, and to a much lesser extent, fire departments. But we capture both fire and police in the category of first responders. I would say they now comprise, police departments now comprise probably about 26% of our caseload, which is a very significant increase. I'd like to also talk a little bit about some of the impacts we have seen over the past 3 years during the pandemic. And in particular, I've tended to view these along two interrelated lines. One has to do with the type of issue that we're seeing coming to us, and the other has to do with the length of time it takes us to get to a matter or to resolve it. In the case with respect to issues, we have seen over the last 3 years, very steep increases in the number of submissions to us that involve where the presenting issue is, I made a request to such and such agency and I didn't receive any response. Or I made a request to such and such an agency, but I got an incomplete response. Or some other issue about whether a response is actually responsive. These types of matters used to be, and in particular, those where the presenting issue was, I have received no response at all. Those issues used to be about somewhere between 18 to 22% of our caseload. We saw, I think at its steepest in 2021, that percentage went up to 65% of our caseload. And I think some of the reasons for this are fairly straightforward, and that is that many agencies were severely stressed and challenged in their operations during the pandemic in many different ways. IT departments were strained by new and expanded needs. There were staff redeployments in any number of agencies to meet new and changing needs. Of course, the Great Resignation has been in the news. And for agencies that have not digitized their record and don't have easy remote access, there were problems related to staff even accessing hard copies of records when those were needed. So I think those factors tended to converge and resulted in what became a very dominant problem of lack of a response. I'm pleased to report that for fiscal year 2022, we did see some movement going back to pre-pandemic levels. It's slow going. We're not where we want to be, but we're going in the right direction. So I am optimistic that with continued effort, continued training, continued education, we will be able to see continued improvement. Beyond issues about lack of a response or very late responses, some of the other issues that we regularly deal with have to do with denials of access to records, either to whole records or parts of records under the exemptions provided in the Act, or sometimes under other law that may be applicable. We regularly see issues and problems related to very broad requests for data, and this sometimes becomes intertwined with fees that may be assessed. Very frequently in those kinds of matters, I try to help parties carve out a much more manageable request or stage things in a way that will be far less burdensome to everyone involved. We also received questions about what does the response mean, or why does a certain exemption apply? I've already mentioned the adequacy of the search issue. We encounter quite a bit of skepticism among requesters as to just what is going on with their request for records. I would turn now with just a few comments about what is for us a very exciting development. I mentioned that in July 1, there were some changes that went into effect under the Public Information Act that affects my program to some extent, but and far more importantly, it expands the jurisdiction of the Public Information Act Compliance Board, which Sarah will be able to tell you about. I mentioned that we did quite a bit of outreach to try to ensure that our program users were informed about the changes and to ensure that we would be able to manage those changes effectively and efficiently. In this regard, many of the committee members will remember this bill, which was enacted in 2021 and just went into effect last year. There were two principal objectives with these changes. One is to provide a decisional remedy, which the board can provide for an expanded range of issues so that requesters would have a user-friendly, accessible means of obtaining a decision on issues when that is needed. The caveat being, the condition being that was placed on that remedy is that mediation has to be attempted first. Mediation through my office has to be attempted before anyone can file a complaint with the board. Having that backstop with the board as a potential remedy for a larger range of issues, we also expected would make the mediation process through my office much more effective. And when I say effective, I mean would help us resolve issues, actually resolve issues and induce parties to engage more meaningfully with our process. The law places for the first time a time limit on my work with parties, and in general, I'm now required to conclude mediations within 90 days, which sounds like a lot, but sometimes it seems just to fly by. We are only 6 months into the new kind of the new program with the changes it brought. But I'm very encouraged to say that from the tracking that we're doing now, it does appear that the changes that were made by the legislature are having their intended effect. We had projected how many matters or what percentage of matters we thought would be resolved under the new regime, how many would be in need of a board remedy. And so far, we are very well within those projections. And in fact, my administrator has been really assiduously tracking this from July 1 through the end of the year. We fully resolved about 73% of our mediation matters, while only, let's see, it looks like about 16% of matters were either unresolved or partially resolved. Now, there are some other possible dispositions that can come up, but essentially we had been projecting that there might be something on the order of 20 to 25% of matters unresolved. And so far, it's still early days, but so far we are really our batting average is well within what we had hoped it would be. And I think it's in large part because the changes made are very effective. And I think with that, I would invite the committee to pose any questions they might have.
I have to say that it's very clear your passion and your knowledge. So you're always very impressive when you come in this committee. So I want to thank you on behalf of our committee and for the work you do. I'm going to open it up. Go ahead.
I just want to re-echo that my assistants, my attorney, Sarah Clem, and my administrator, Spencer Dove, are linchpins in this entire program.
I have to tell you, Spencer started, he actually worked for me many, many, many years ago. So it's good to see that he's doing well, because I take it personally. Are there any questions? Any questions? Yes, Delegate Collison.
Thank you, Madam Chair.
pleasure.
Thank you so much for that report. It's actually really exciting following the reform of the PIA bill that we did back in, I think, 2016 or 2017. I know one of the issues, and I'm really happy to hear about the percentage of cases that are being resolved prior to the board's engagement. One of the concerns that I know that you raised in the hearing when we passed the bill in 21 that allows you to do that was staffing. And I hear you have 2 staff members. I guess the question I have is, are you able to keep up with the demand now with the staffing that you have?
Well, I think my answer is going to be in 3 parts. One, I believe that at the present time, we are managing our caseload effectively and competently. So there is no dire emergency that we do not feel underwater. Number 2, there is no doubt that the changes that have been made have created more, there are more steps in our process. There is a need for greater precision in certain respects in defining issues and outcome. And much of the burden of this is falling on our administrator, who frankly is doing hero's work in terms of supporting the Ombudsman program and the board at the same time. So that is a very, in my opinion, that we could well use additional staff in the form of an additional administrator, potentially maybe a person who has paralegal training to assist with board processing. We're still in the early days of implementing, and so I would like to reserve the opportunity to come back to you next year and with a little more data and to answer you more precisely. The third aspect of my answer, Delegate Cullison, is that as things stand right now, there is no room, there is no cushion for any sort of absence from the workplace. So that means, for example, that if one of us were to fall ill and if we were to get COVID and be out for a couple of weeks, it creates hardships and problems. If something more serious were to happen, it would be a problem. Taking a vacation can be a problem. And so I don't want to complain at a time when so many people in our community, in our country, and in the world are suffering true hardships, almost beyond belief. So I do not want to be heard to complain. But the point I'm trying to make is that I think in the long run, in the long term, it would be very beneficial and perhaps necessary to add staff of the sort I just mentioned, additional administrator and or paralegal, or both.
My pleasure. We have next Delegate Hill.
Thank you, Madam Chair, and thank you so much for testifying. And I know we've just put, as you pointed out, some changes in place. I'm going to sort of follow up to Delegate Cullison. There were tools that we discussed when this last bill was heard that you were not given, right? So the 2 questions are there additional tools that you still would like the General Assembly to consider giving you in terms of enforcement or any other things to help you do your job? And the second part is, with the other changes we've made in public information and other access issues, do you think that we will approach a time where there will be fewer demands, fewer needs for you to step in and serve in the ombudsman role, that our system be working well enough that that public agencies and groups and bodies will be working better, that your role will be diminished? So one, other tools, and the other, what do you project?
Yes. Let me take your last question first, if I might, because it's very, very forward-looking and optimistic. I can be very optimistic with this. One of the things I have, first of all, it's hard to assess what will happen in the future with any certainty, but I have noticed, and we have some direct program experience, that when we work with agencies, for example, if we see systemic issues, we have had occasion to reach out to agencies, ask for a meeting with with the relevant staff, perhaps with their counsel. We sit down and try to talk to them about ways they could, other ways they might approach it, other agencies they can talk to about how the other agencies are doing things. We ask if they would be interested in having trainings. And when we invest that kind of time, which is tailored to the needs of a particular situation or agency, we see improvement. And I have seen this any number of times, to see real improvement. Now, it does seem to be the case that when one agency improves, the problem pops up somewhere else. Agencies are big organizations. They have constant turnover of staff, changes in administration. There's a need for training should be a regular activity. You know, the other component of this is the requester population. Most of the people I work with are not lawyers and are not professional users of the Public Information Act. And I am not anticipating that the need for assistance to many of those people would ever disappear entirely. I think it is very beneficial to have someone who's in a position to talk to a requester about why a certain record can't be produced, or another way to get the same information. We all know there's a great deal of, well, we are in a very tense time around government, and I think that to the extent people can be reassured that you know, at least here in Maryland, there is a very concerted effort to make things work right for the people and to be transparent, to be very helpful. So no, I'm not really foreseeing that it will ever go away entirely. Will there be improvement? I'm optimistic. I'm very optimistic that we will see improvement. In terms of tools, I think I've already addressed the staffing situation. I hope and expect to have more detailed data for this committee next year. We'll issue our next report in, I'm anticipating August or September of 23. My office does not have any decisional authority, and I don't think it would be appropriate for us to have it. That authority now rests with the board. The board, while it has expanded jurisdiction, still does not have plenary jurisdiction under the Act. There are certain issues that it still can't address, and that would be something I will defer to my colleague Sarah Clem to talk about how she feels the work of the board is going. But I think one of the strengths of my program is that, frankly, I don't have enforcement authority, because I can create a safe space for people to talk to me, and I'm offering them an alternative to having a published decision issued by the board that will involve more work for them to respond to, maybe embarrassing, you know, and we can deal with problems by agreement in a confidential setting. I have a better chance of putting parties on a better footing with each other in a way that would be meaningful going forward. That is very often my goal, is to try to help facilitate a better relationship between the two parties, particularly if they have to deal with each other repeatedly. The Office of the Attorney General has been very generous and responsive to the needs of my office in terms of, you know, the hardware, the software, the infrastructure that I need to operate. So I do not need any tools in that regard. I do think that it will be important to look at the data that we develop as we move forward under House Bill 183 to really assess this further. I will say that I think that expanding the board's jurisdiction has been extremely important, and I'm very optimistic there'll be many benefits from that having occurred.
Thank you.
Thank you. Any further questions? Yes, Delegate Alston.
Thank you, Madam Chair. I have a two-part question. The first is there a mechanism for you all to extend beyond the 90-day time parameter? Because I'm concerned with the caseload and the number of mediators that you have, that seems like a pretty daunting schedule for any person to have to live within. And if you don't have that ability, would something like that be helpful? Thank you.
Thank you for that question. I do have the ability to agree to an extension if the parties are agreeable to it. And we have used that mechanism a number of times since July 1st. I'm happy to say that we have not used it. For the most part, we are not being required to use it. One of the things I like about the 90-day deadline, even though it creates a little additional pressure for us, is that it allows me to really motivate parties to move along. The longer things drag out, the harder they become to resolve, the more work it is to resolve. You have to keep reinventing the wheel and getting refreshed as time marches on. And sometimes the requests just go stale. So having that 90-day deadline is very helpful to allow me to try to keep the parties on track, to keep things moving, but I still have the flexibility when I think we're making progress in a matter it just requires more time, and that happens from time to time. I ask the parties, would they agree to an extension, and then we set an extension. I have found that parties are, if we're making progress, they're very happy to have an extension because they would like to resolve it that way and not have to go off filing complaints. So I do think we have what we need in that regard.
Any further questions? Seeing none, thank you so much for your work and your dedication. It shows, and we appreciate it.
Thank you, Madam Chair. Thank
You have a blessed day. Thank you.
Thank you. You do the same.
Our pleasure. Next, we have Ms. Sarah Clem, and she's the Assistant Attorney General for the Public Information Act Compliance Board. And she will be our last virtual witness for today. Then we have two witnesses present in the committee room. Good afternoon. How are you?
Good afternoon, Madam Chair. I'm well, thank you. How are you?
Good. Thank you for asking, and welcome to the committee. You can get started.
Thank you, and good afternoon again. My name is Sarah Clem. I am an Assistant Attorney General, and I serve as counsel to both the Ombudsman and the Public Information Act Compliance Board. And my plan today is just to give you an overview of what the board does. And I'm sorry, I just realized. Sorry about that.
It's okay.
One of the drawbacks to presenting. My plan is to just give you an overview of what the board does and how some of the recent changes have affected its operations. So the Compliance Board, as Ms. Kirshner explained, was established in 2015 through legislation that was enacted, and I know several members of this committee were sponsors and co-sponsors of that legislation. Originally, the board was given broad jurisdiction, but that jurisdiction was scaled back at that point to allow the board to consider complaints of unreasonable fees higher than $350. And so for that time period from 2015 until just recently, that was the only issue that the board was authorized to review and resolve. Currently, the board it's a 5-member board. They are all volunteers who are appointed by the governor and confirmed by the Senate. The statutory composition of the board changed a little bit recently as well. Right now, the board must have 2 lawyers, one member who has custodial experience, and that member is nominated by MACO and MML. Another member is from an organization that works on open government issues, and that person is nominated by representatives of open government and news media. And then this is one of the new requirements, is a member must be familiar with electronic records and electronic record keeping. And although, as I said, those requirements just went into effect over the summer, right now the composition of the board does satisfy those statutory requirements. And the board's annual report, which was provided with the materials, I think gives you a little bit more information about exactly who those members are and what seats they fill. The board members all serve staggered 3-year terms, and they cannot serve more than 2 consecutive terms. I would note right now, there are 3 of the 5 members are holding over after the expiration of their terms, and that includes the board's chair. And there is a 4th term that will expire at the end of June of this year. So we expect to see some movement in terms of board membership over the summer. The board is an independent entity, just like the Ombudsman's program, but it does not have a budget or office of its own, so that it's entirely supported through the Office of the Attorney General, specifically the Public Access Unit, which is myself and Spencer Dove acts as the administrative officer for the board. We do need to keep sort of a wall of separation between the Public Access Unit and the rest of the Attorney General's office, because there's a chance that there could be a complaint involving the OAG that comes before the board. So, we're part of OAG, Spencer and I, but we're also somewhat walled off a little bit. So the bill took effect in October of 2015. The board issued its first decision in March of 2016. And then for the ensuing years, averaged about 6 to 7 written opinions per year, again, all on the limited issue of whether or not a fee was reasonable. I would note that a lot of the complaints during that time were dismissed without written opinion because the board just very clearly on the face of the complaint did not have jurisdiction. So if someone filed a complaint about being denied access to records or their custodian didn't respond, the board wouldn't issue an opinion because they very clearly just did not have authority to do so. I think that it was fiscal year 2022 was the year in which I think there were 10 opinions, written opinions issued that year. And again, that's, they were limited to that fee issue. And that's the most that the board issued in any one given year, fiscal year. I think that is going to change. We've already seen signs it's going to change largely with the changes that House Bill 183, which was enacted in 2021 and took effect this summer, have brought about. So I think most importantly, what that bill did is expand the board's jurisdiction. So in addition to reviewing allegations that a fee higher than $350 was charged and is unreasonable, the board can now review denials of access to public records, a custodian's failure to respond, and then also sort of on the flip side, a custodian could bring a complaint that a request is frivolous or vexatious and sort of seek relief that way. And again, as the Ombudsman explained, everyone starts with Lisa's shop. They all have to attempt mediation. There are times I think when a custodian may not engage in mediation as much, either because they are, very firm in their position that a mandatory exemption applies, and that's just sort of the, where it ends for them. And so in those cases, a person is still able to file a complaint, even though maybe a sort of full-fledged mediation hasn't occurred. So there's no way that a party can sort of try to get around filing a board complaint by just refusing to participate in the Ombudsman's process. Again, that the parties have up to 90 days in general to try to resolve their disputes sort of more informally and confidentially through the Ombudsman. And if they're not able to resolve it and they get a final determination that says it was not resolved, then the party can go on to file a complaint with the board. Since this change took effect in July, the board has received 12 complaints. 3 of them were dismissed without a written decision because mediation hadn't been attempted. So there was no jurisdiction for the board to consider the complaint. But the rest of them, the board has reviewed the complaint and has issued a decision, except for there is one that is still pending. 6 of those complaints involved some type of denial of access to public records. So a denial of the entire record or redactions of information, or a constructive denial. We had a complaint where the custodian their response was, we don't have any records for you. And the requester believed that the custodian hadn't looked hard enough for those records, or that they had them and they were hiding those records. So the board considered that as a constructive denial. 2 of the complaints have involved a custodian's failure to respond. And one of the complaints involved a challenge to a custodian's proposed search method. That one, the board did conclude that it did not have jurisdiction in a written decision, it just as not being right yet for review. The board has issued 7 written decisions so far, and those are posted on the board's website through the Attorney General's office, and I believe that link is provided in the board's annual report. And one of those written decisions actually involved 2 complaints. There was same requester, same agency, same sort of general issue. So the board has definitely been busier this first half of the fiscal year than it has in years past. Also, just a couple of quick notes on the general process itself. The statute does provide for appellate review by a Maryland Circuit Court. So either the complainant or the custodian, once they get the board's decisions, has a right to go to the circuit court, where the circuit court sitting as an appellate court will review the board's decision. If an appeal is filed, the board's decision is stayed. I am not aware yet that any of the decisions have been appealed, but it's certainly something that we anticipate will happen at some point. And there's also, I just note, there is no requirement that a requester use the ombudsman's or the board's process. Somebody can still go straight to court if that's what they want to do. And we are still seeing, just recently, the Supreme Court of Maryland heard argument on a fee waiver issue. So there certainly are still, cases that are percolating in the courts related to PIA issues as well. One last thing quickly, the House Bill 188 also required the board to adopt regulations, which it did do over the course of 2021, late 2020, or 2021 and 2022. And those regulations became effective in June. And they're very procedural, but just give a little bit more detail about the board's process and things like that. So that, I think, is all I've got for the committee today, unless there are questions.
I will now open it up for questions. Are there any questions? I don't see any. You did a great job. Thank you for being with us, and thank you for your work, okay?
Thank you. Thank you very much.
Take good care. Right? Now we're going to actually go to our second panel, which is an overview of the Maryland Commission on Civil Rights. And we have 2 speakers. The first one is Ms. Glendora Hughes, who's the General Counsel for the Maryland Commission on Civil Rights. And the second one is Mr. Cleveland Horton, who's the Deputy Director for the Maryland Commission on Civil Rights. Good afternoon.
Good afternoon. Good afternoon. Good afternoon, Madam Chair and Madam Vice Chair and members of the committee. I'm Glendora Hughes, General Counsel for the Maryland Commission on Civil Rights, and here with our Deputy Director, Mr. Cleveland Horton. I hope this goes well with the slides and the talking.
It will go well.
Okay, all right. Always different forms of technology here.
It's okay.
So we thank you for the opportunity to share and provide you some information on the Maryland Commission on Civil Rights, to give you an idea of our agency and the process and things that we do at our agency. The Maryland Commission has been in existence in some form since 1927. And it has evolved over time in terms of working to look at specific issues dealing with race, and then proceeding to add other areas of concern, and then gradually obtaining enforcement ability with the Article 49B that is now State Government Article Title 20 And during that process, there have been additional coverages and mandates, which I'll go through. And then Mr. Horton will go through our case processing aspect, and then I'll come back and finish up with what happens when a case is litigated and goes on to litigation in court or at the Office of Administrative Hearing. So Title 20 is the state government article. Title 20 is the, whoops, wrong way, is the statute that we enforce, but we have some other pieces in other statutes that we had been given authority or concurrent jurisdiction with, and I'll explain those. The main Title 20 coverage is we have jurisdiction over cases that arise in Maryland that involve discrimination, unlawful discrimination in employment, housing, public accommodations. Those are the core areas that we have in enforcing the state's police power. Subsequently, we were given a jurisdiction over what is called commercial non-discrimination, which prohibits discrimination by an entity that is has a state contract. And if that entity is shown to be discriminating, rather in their employment or in the process of implementing that contract with the subs or subcontractors, then the entity could be debarred from being able to get future contracts. And it also mandates that there is a clause in the contracts, all state contracts, indicating that commercial discrimination is prohibited and that the state would not do business with entities that discriminate. Then recently, I believe in 20, I think it was the session, the 2021 session, we were given concurrent jurisdiction with the Department of Health involving healthcare discrimination in healthcare services and discrimination in healthcare facilities. And part of that is that the health department has expertise in terms of the health and medical issues, but in terms they would share if there is a issue or complaint raised that involves discrimination, and if there is an issue that involves discrimination in the implementation of the service or facility, discriminating and turning folks away because of a protected class, then that information is shared with us, and vice versa. If we get a complaint that involves health services, or we will contact the Department of Health and for their expertise or that particular board that deals with that particular issue, and we would work with them on that piece. We have had for some time concurrent jurisdiction with insurance, the Insurance Commission, and that similar situation, similar relationship. If there's a complaint involving insurance, that a person saying they're being discriminated because of their insurance, we do contact the Insurance Commission because they have sole jurisdiction dealing with actuals and insurance issues, and they're their expertise, but we would handle the discrimination aspect of that complaint. Finally, we are charged with doing sexual harassment training of the trainers. The state mandated that all state employees receive sexual harassment training, and part of that statute, the scheme, was that each agency was identify unit leaders who would do the training, and our responsibility is to train those trainers to go back and implement the training of sexual harassment and ensuring that the agency is training persons every 2 years. All persons have to have training on sexual harassment every 2 years. And so we conduct training of the trainers, and the statewide EO coordinators does the audit to see if there's compliance by the agencies. The areas, the protected classes that the commission has presently are on the screen: race, color, religion, sex, national origin. Familial status is a protected class in housing only. Marital status, physical, mental disability. Age is in employment and public accommodations only. It's not in housing. And one reason why it's not in the fair housing law is because there is exceptions that permit the construction and the rental of units based on age. So you have 62 and older housing, and you have 55 and older housing. So that's one reason why age is not a part of the Fair Housing Act. Sexual orientation, genetic information is in employment only and not in the other areas. Gender identity, and our latest protected basis that was added recently is source of income, which is in housing only. We do work with federal partners as a part of the nationwide enforcement scheme, where you have federal, state, and local agencies working together in partnership. As a result of that partnership, we have a work-sharing agreement with the EEOC and a work-sharing agreement with HUD. With the EEOC, in part of that work-sharing agreement, we make sure that a person, if they file a complaint, that we both will not be working on the same complaint. The person has one or the other. And if the situations where we have, in terms of our computer system software, we're able to see whether or not the person has a dual file complaint and determine which entity is going to conduct the investigation of that complaint. As a part of that relationship with the EEOC, we have a contractual contract which they assign, enter into a certain number of complaints that we investigate. And all these are complaints that arise in Maryland, and as a part of that contract, and we share information and we share resources and training with EEOC. The relationship with HUD is a little different in that every complaint that arises in Maryland is investigated by our agency. Even if HUD takes the complaint, if the person goes to HUD, they must defer that complaint to our agency for investigation, unless it is something that they would like to have, or it has national implications where you have an entity that has multiple issues in multiple states. They may request us to refer the case back to them. But normally, because we are what they call a substantially equivalent agency, meaning our statute is similar to Title VIII, the federal law, that they have to defer all complaints that are filed in Maryland to our agency for investigation. And with that, I'm going to turn it over to Mr. Horton to discuss how cases go through our complaint process.
Thank you, Glendora. First of all, thank you, Madam Chair, members of the committee, for giving us this opportunity to kind of brief you on who we are as a Commission on Civil Rights and how we process cases. My name is Cleveland Horton. I do currently serve as the Deputy Director for the Maryland Commission on Civil Rights. And as you all can see by the screen, we do like colors, right? So, when we think about our caseload, and Glendora,
That actually woke us up.
there you go. So, when we think about our caseloads, Glendora did indicate our three core areas in employment, housing, and public accommodations. Our caseloads are probably about 75% employment. That is the bulk of what we see coming into our agency, either directly or through EEOC. We have another 20% that are housing, and then the rest are kind of public accommodations and state contract cases that make up that remaining 5% or so. So the key question typically is, well, how does someone file a complaint? How does somebody reach out to the Maryland Commission on Civil Rights. And there are multiple ways to do so. Individuals have the opportunity to contact us directly via phone. They have the opportunity to go onto our website. They have the opportunity to email or faxes. Prior to the pandemic, we were scheduling in-person one-on-one appointments in our intake office. We have kind of course, pulled that back a little bit as a result of COVID-19. Most of our appointments are currently being done virtually. But we do want to make sure that everyone has direct access to us. So even those who are kind of challenged with technology and don't have the means to access our agency via technology, we will make an exception and allow them to come into our agency directly and file a complaint. Once someone really reaches out to us to file a complaint, they have to fill out what we call our preliminary questionnaire. And that really just kind of goes through the basis of their complaint, who's the respondent, what happened, when did it happen, and what's the protected basis for the complaint. From there, our office secretary takes our PQs. She will analyze them to make sure, one, that it's timely, and to make sure that it is an area that we have jurisdiction over. Once she determines that, in fact, it is jurisdictional, she will schedule that individual for an intake appointment to meet with one of our intake officers. That typically happens within about 10 business days, because we do want to make sure that we are getting individuals in timely and in a reasonable time to make sure that we can at least get the complaint process started. Once they have the opportunity to meet with one of our intake officers, they do have the opportunity to bring any information with them, relay any information over to the intake officer, give the intake officer any type of remedy that they are seeking as a result of the alleged discrimination. Once our intake officers have determined that we do in fact have full jurisdiction over the matter, after they've had the opportunity to have that interview with the complainant, they draft the charge. It's signed off by one of our supervisors authorizing the charge, and we serve that charge to both the complainant and to the respondent within 10 days of that. The respondent from there has about 30 days to submit their position statement to us, which is basically their response to the allegations of discrimination. And from there, the case is, of course, assigned to an investigator or assigned or scheduled a fact-finding conference. Move on to the next slide for me. It's nice to have your own personal clicker, so I appreciate this. So we do have two tracks when we think about investigations, right? We have our fact-finding conference, and of course, we have our traditional method of investigation. We created the fact-finding conferences probably about 10 years ago to make sure that we were able to expedite cases through our agency. When individuals come to us, there's an issue. Whether they're able to prove the issue or not, the bottom line is it's still an issue, whether it's perceived or not. It is our goal to make sure that we're able to kind of get these cases through our agency as quickly and as efficiently as possible. And we found that through the fact-finding conference process, we were able to do so. We haven't gotten rid of the traditional method, but we typically, all of our cases, with the exception of some of the sexual harassment cases, those cases where it's not the best idea to have the parties in the same room at the same time, those cases still go through the traditional method of investigation. The main purpose of the fact-finding conference is to allow the complainant and the respondent to come before our investigator and present their positions as it pertains to the allegation of discrimination. Both parties have the opportunity to bring in any information, any witnesses, anything that they believe helps prove their case or rebut the complaints of discrimination. So when you think about looking at our timeline through our fact-finding conference process, the initial case review, which our investigator is at that point in time notifying the party that the case has been assigned to them, that gives them the opportunity to begin to kind of go through the case file and ask for any preliminary information that they believe that they'll need prior to the fact-finding conference. Our fact-finding conferences are typically scheduled about 60 days out. When we initially started this process, we were scheduling our fact-finding conferences probably about 15 to 30 days out. Well, what we encountered was all the attorneys were like, well, my schedule is already booked 15 to 30 days out. So to give deference to attorneys in that schedule on both sides, we wanted to make sure that we scheduled our fact-finding conferences in a way that allowed both parties to make sure that they could attend and have the appropriate representation, if need be, at our fact-finding conferences. During the fact-finding conference, it's also our opportunity to really separate the parties and talk to each party about the case, go through the strengths and weaknesses based off the information that has been presented to us. It also gives us an opportunity to settle the case. We know that through the Maryland Commission on Civil Rights, we are more than just issuing a resolution. Our goal is to figure out if there's a way to come to an amicable resolution through the conversation with both parties. The fact-finding conference typically allows us to settle anywhere from 40 to 45% of our cases simply going through that process, and it has served great dividends for our agency. As you'll see, typically through our normal process, going through the fact-finding conference process, we are typically able to get cases through our agency within about 180 days from start to finish under normal conditions. If you also look right below, you'll have what our timeline or trajectory looks like through our traditional method of investigation. The big difference is that we're not bringing the parties together at one time and gathering information simultaneously. During our traditional method of investigation, we are contacting each party individually, gathering information, and then reaching out to the other party for additional information as we kind of go back and forth between the parties. As you all, I'm sure, are quite aware, that kind of takes time, right, to interview one party, go back to the other party, gather additional information, then go back to the other party and allow them to respond to it. So that's why you'll see the distinct difference in time going through the traditional method. Our traditional method typically takes us about 300 days of investigation from start to finish. Once we've gone through either through the fact-finding conference or through the traditional method of investigation, and we've gathered all the details that we need to make a determination, our investigators will make a recommendation to their supervisor, and that recommendation will either be a no probable cause recommendation or a probable cause recommendation. Once the supervisor has had the applicable time to review the case and all the information pertaining to that case, they will either concur with that recommendation and have the finding issued, or send the case back to the investigator for additional investigations moving forward. The no probable cause, once we issue it, the parties do have 15 days. The complainant has 15 days to appeal or make a request for reconsideration of the no probable cause finding. That request comes directly to me for my review. At that point in time, I take a look at the case file in its entirety, go through all the information that was submitted by both parties and all the information that we had, witness interviews, documents, things of that nature. At that point in time, I will determine whether I am going to grant the request for reconsideration and remand the case back to investigation, or I'm going to concur with the final recommendation of the no probable cause finding, and that becomes the official order of the Maryland Commission on Civil Rights. If we determine that it is a probable cause, the case is reviewed by myself as well as our legal team to ensure that we all are on board with the probable cause and that we've covered everything to move forward beyond just the investigative stage of the case, because again, at that point, it is potential litigation. Once myself and our legal team has had the opportunity to concur with the probable cause finding, we will issue the probable cause finding. There are no appeal rights for a probable cause finding, so once we issue it, it is our final decision at the Maryland Commission on Civil Rights, and we move forward that way. The parties do have an opportunity to enter into what we call conciliation at that point, where we again attempt to settle the case, and if there's an opportunity to do so, at that point, our investigators will spearhead the conciliation of the case at that point in time. If conciliation fails, we will certify the case for public hearing, and then the case is forwarded over to our wonderful legal team to begin the litigation process. So one of the things I do want to point out when we talk about on this slide, when we look at our time and process for both tracks, we look at the fact-finding conference track where we're about 180 days, and our traditional method of investigation where we're about 300 days. We have had some challenges, and those challenges have pushed our time and process out drastically. So now we take a look at our fact-finding conference process. We're probably, for both tracks, to be honest, we're probably about 18 to 24 months out from a time and process standpoint. So I'm sure you all are wondering, well, what are the challenges, right? And I'm glad you all asked. Right? So when we think about what has happened at the Maryland Commission on Civil Rights, in fiscal year 2015, we were bringing in probably around 500 to 550 complaints as an agency. In fiscal year 2016, we brought in 996 complaints of discrimination. We doubled the amount of cases that our agency was seeing, and unfortunately, we did not double the staffing that we had at the same time. Our agency has, over the years, been trying to streamline, be more efficient in everything that we do to manage the cases that we see coming in. But I'm sure, as you all know, you can only streamline but so much. We're finding that, and of course, many of you all know that complaints of discrimination are not the same. Complaints of discrimination are not as overt as they used to be. Yeah, it is our job at the Maryland Commission on Civil Rights to make sure that we are taking a look at everything. Technology now plays a part in discrimination. So we have to be trained and experienced enough to understand how to get into the technology to make sure that we have truly taken a look at everything in order to make sure that we're making the correct determination. So as a process of the allegations and the actions of discrimination changing, we've also had to evolve, which is also taking a longer period of time for us to get through some of our cases. Our federal partners have required significantly more administrative work for the cases that we do for them. Each of our federal partners have databases. Prior to that, we used to do investigations. All the information that we would collect would go into a case file. We would send over, sign off, and just send us the original case files back. Well, now with technology, and we all love technology, right? We no longer send the hard copy files over to our federal partners. So now they want everything uploaded into their databases. So all the information that our investigators are getting, they now have to duplicate that information, upload it up into the databases. So there's just a lot more administrative work that we're seeing through our cases. We also take a look at staff turnover. At one point in time, the Maryland Commission on Civil Rights was probably about 95% retirement age. Most of those individuals have gone on to enjoy every day being a Saturday. But we find ourselves transitioning into a younger workforce and dealing with the staff turnover and trying to make sure that we have the right people and keeping the right skill set. We truly do have a committed staff of employees at the Maryland Commission on Civil Rights. But as a result of that, employers have the opportunity to be in front of them every day as well. And they take the opportunity to recruit our employees day in and day out. Unfortunately, we don't pay the most. So those employers have been able to pick off a lot of our talented skill set individuals and bring them over to what they call the brighter side. But again, not to sound like this is doom and gloom, there's just some of the issues that we've been facing at the Maryland Commission on Civil Rights. When we take a look at competing salaries, we take a look at the work that we do, the amount of work that we do and the amount of money that we pay our employees. When we did a salary analysis comparing our agency to other local, state, and federal agencies, we realized that we were paying our employees the least, but we were expecting them to perform the most. Taking a look at our production requirements. Our other agencies, local and state and federal level, typically require at the most that we uncovered 30 to 40 cases per year. Well, our entry-level investigator requirement is 54. It goes all the way up to 78. So we do require our staff to do more than double the work of all local, state, and federal agencies. When we also took a look at, from a salary standpoint, where we were on average about $15,000 to $25,000 less at every classification than all other local, state, and federal agencies. Now, we have had the pleasure of getting a salary increase, and our employees are tremendously appreciative of that, and that went into effect January the 1st. We haven't seen a salary increase of that magnitude in the last 20-plus years at our agency. So our employees are definitely appreciative of the fact of being able to do so. But that's also aided and played a part in the staff turnover that we've seen at the Maryland Commission on Civil Rights. Our caseload capacity. As I mentioned, that since our caseloads doubled in fiscal year 2016, our investigators were at one point in time handling 140, 160 cases at one point in time. Our goal was always to make sure that outwardly our numbers were right. As a leadership team, we really had to take a step back and ensure that not just our numbers were right, but we needed to make sure that our employees were right. Our staff was burning the candle at both ends, working 60, 70-hour work weeks just to make sure that we could sit in front of everybody and talk about the great numbers that we've had. So we did have to reduce that just to make sure that we were able to maintain our employees. Getting into the area of civil rights, we always talk about civil rights being a very sexy topic, right? And individuals wanting to say that they are committed to and supporting civil rights and being able to work in this arena. But behind closed doors, it is a lot of work, right? It is a lot of work. The phones are ringing constantly, day in and day out. And typically it's not to say thank you. It's typically to say you're not doing your job, and let me tell you how you should be doing your job, right? And as a result of that, again, a lot of our employees, because of that mandate and that requirement, have sought additional employment. So from a leadership team, we did take a look at that. We've made a concerted effort to reduce our caseloads. Now we're probably averaging somewhere between 45 and 55 per investigator. But as a result of that, I'm sure many of you all with the constituents that you serve have received phone calls about, hey, I filed a complaint with the Maryland Commission on Civil Rights. I haven't heard anything. It's taking them a significant period of time to get to our cases. And we'll be the first to acknowledge it is. We understand that that's unacceptable, and we're doing everything that we can as well to address that. But we need to make sure that the individuals who are on the front line on behalf of the Maryland Commission on Civil Rights have the opportunity to get through these cases in a timely manner, but more importantly, to make sure that every investigation that leaves out of our agency is a quality investigation. I prefer that individuals do the investigation right versus do the investigation quickly. Those are some of the challenges that we faced. And even doing that, when we take a look at the number of cases that we have unassigned, approximately 18 months ago, we probably had somewhere upwards of 500 cases that had been unassigned, waiting to be assigned to an investigator. We've been able to bring that number down. We're probably hovering around 300 cases that have been unassigned. The average time and process is impacted by the number of cases that are unassigned. Most of the cases are sitting in queue, waiting to be assigned, probably for about 12 months. So when you take a look at, when I talk about the 18 to 24 month time frame, if you take the 12 months that is sitting in queue potentially, that's why you see the drastic difference in where we are now. At one point in time, our agency was one of the best in the nation from a time and process standpoint. Unfortunately, fortunately, depending on how you look at it, because of the amount of cases we've received, it's drastically impacted our time and process. But on the bright side, we still are here. We still remain committed to getting through each and every case. We still remain committed to making sure that we are enforcing our anti-discrimination laws here throughout the state. We know that it's a lot of work to be done. We have a long way to go, but we know that we'll get there and we'll get back to where we were as we continue to get additional resources. We just received the authority to add in 3 contractual positions that we believe will, again, serve dividends to us. We still believe that we're probably, from an investigation side, probably about 8 to 10 positions short of what we need to handle the amount of work that we have coming into our agency. Keep in mind that we have, because of our federal partnership with EEOC and the great work that we've done for them over the years, we typically receive anywhere from 300 to 400 cases from the EEOC every year. We've had to halt those cases, and they've been kind enough to allow us to halt those transfers in for the last couple of years because of our staffing deficiencies. But they are now saying, hey, look, we do still have to transfer those cases over to you because of our partnership. So once those cases start back up being transferred back into our agency, again, our caseloads are going to continue to climb, and potentially our time and process as well may continue to climb as well. So I just wanted to again, it's not doom and gloom. We just wanted to make sure that you all have a full picture of kind of where we are as individuals are kind of calling you all, letting you all know, hey, I filed a complaint. I haven't heard anything. We know about it. We're on it. We're doing the best that we can to make sure that we're serving the citizens of Maryland and making sure that we are enforcing the anti-discrimination laws. But again, we will get through it. We don't expect that we'll get back to the case levels prior to fiscal year 2016. But we see that as a good thing. As more and more individuals are aware of their rights, more and more individuals are exercising their rights. And that should be the goal. We take a look at our housing cases. We only receive about 120 to 150 fair housing complaints on a yearly basis. Well, we're in a state that's over 6 million people. We know that there are far more fair housing issues and fair housing discrimination complaints out there that we simply aren't receiving. While we love to be out there pushing for more people to file, we also have to be honest and realistic in the fact that we are at a point where we can't handle too much more without any additional resources. But with the help of our wonderful general counsel and our education and outreach team, we continue to plug away to make sure that every citizen in the state understands what their rights are and how they can reach out to us in the need for our assistance. And we stand committed to that. So I just thought that it'd be good for you all to understand some of the challenges that we are currently facing, but that we still do, again, remain committed to our vision to make sure that we eradicate discrimination throughout the state. And with that, I'll yield back to our general counsel.
Thank you. Is this on? Yep. Okay. Thank you, Cleveland. I will just briefly go through in terms of litigation. The Maryland Commission on Civil Rights is an independent agency. That being said, means that we are not staffed by the Attorney General's office as the representative. And the reason why that we have independent counsel, a general counsel, myself, is because the state waives sovereign immunity in employment cases, and we can bring actions against the state and state agencies. And the General Assembly, you all determined that you didn't want the AGs on both sides of the table, both being the prosecutor and the defense. So an independent counsel was created in terms of litigation. So Cleveland pointed out that a case is certified for public hearing. And when the case is certified for public hearing and it comes to the general counsel's office, both parties have the option in terms of where they want what forum that the case will be heard. Either party, the respondent can elect, or the complainant can elect to have the case heard at a civil litigation in circuit court before a jury. Or the complainant may elect, if they have their own counsel, to pull the case out and file a private right of action in circuit court. And if neither party makes an election, then the default form will be the Office of Administrative Hearing. Persons are given that period of time to elect, 30 days to elect, or after 180 days of the commission having the case, the complainant may pull the case out and file in circuit court. They have met the requirement of administrative exhaustion. As stated, if there's no election, then the case will go before OH. If it's in the circuit court, the statute of limitation is 2 years. With the recent amendment in employment, it's 2 years from the point that person, that the agency finished its investigation. The statute of limitations in filing in circuit court will begin to run. If it goes through a civil action where the general counsel's office will represent the complaint, will file the complaint, then we have 60 days to file the bill of complaint in court. If there is no election, then we file a statement of charges before the Office of Administrative Hearing, and an administrative law judge will hear the case. And the difference between the two is that there is more extensive discovery in a circuit court hearing where you have depositions and interrogatories, whereas in an administrative hearing, the discovery is limited to requests for documents and things. There are no depositions and no interrogatories, and it's a much faster process than a case that ends up in a jury trial. In the administrative process, if there is a trial before administrative law judge and there is an order that is issued, if the complainant prevails, the respondent can obey the order. If the case is a decision where the complainant doesn't prevail, then there is a right to appeal to the commissioners. We have a 9-member commission, And out of those 9 members, a 3-commission panel is selected to sit as an appeal board that would hear the appeal back to the commission from the ALJ decision. From there, if the party is not satisfied with the decision of the appeal board, and that's when it becomes a final decision of the agency, they may appeal to the state circuit court, an appeal, and on up to the appellate courts. So as you can see, there's the circuit court, there is the appellate court of Maryland, and the Supreme Court of Maryland, where if cert is agreed to, then the matter can go up to the Supreme Court of Maryland, and a decision is rendered at that point in time. So that's the process that will occur when a case reaches the level where it's certified for public hearing and litigation begins. And at that, that ends our presentation, and we're open for questions.
I have first Delegate Johnson, followed by Delegate Rosenberg, then Delegate Kelly, then Delegate Morgan.
Thank you, Madam Chairman, and thank you for the presentation. That's quite a workload. Do you have any idea of the percentage of the cases you take on that, I'm just going to call it for conversation's sake, valid cases versus someone who thought they had a valid case?
Probably about 50%, right? So we're taking in probably about, if we're taking in probably about 800 or 900, we probably have the same amount in aborts. One of the things about our agency is we get calls about everything, about my parole hearing, food stamps. Individuals do call us just about everything from A to Z. So we probably have just as number of aborts as we do actual complaints that we bring in.
And Madam Chair, just a little bit. So how far into the process do you have to go before you realize that that's an abort case?
For some of them, immediately, once they call us and let us know what the issue is. For some of the other ones, it really is once it's sent over to our intake officer for them to make the appointment, and they actually have the opportunity to sit down with the individual, gather more information. They can make a determination that that particular inquiry needs to be aborted. For the most part, out of all of our aborts, you're probably looking at 75% of those make it to our intake officers, and about 25% of them are kind of immediately washed out through our initial review in the initial stage.
All right, thank you. Thank you.
My pleasure. Delegate Rosenberg, followed by Delegate Kelly.
My related questions have to do with fair employment. You said that a majority, I thought you said 3/4 of your cases are fair employment cases. Has that historically been the case? And what kind of cases are brought within fair employment, and and in addition, how many have been brought as violations of equal pay on the basis of gender, the so-called Lilly Ledbetter cases?
Yeah, so historically, we've always been an agency that's had more employment cases than housing cases. Our contract with our EEOC is much more significant than our contract with HUD, and the fact that we take a look at the number of employment complaints of discrimination that we receive versus the number of housing complaints that we receive, for instance, is drastically different. As indicated, again, during my testimony, we only receive probably from a housing standpoint about 120 to 140 or so, maybe 150 housing complaints a year. From an employment standpoint, we're probably receiving between actual complaints and aborts, we're probably somewhere close to 700, 800, 900 in regards to employment. Public accommodations is also a very small number. We typically carry at any point in time only about between 35 and 50 public accommodations cases at any one point in time. So historically, that's typically always been the case. In reference to the types of cases that we receive. Previously, historically, race has always been, had been our #1 category in employment. Race has now dropped down to, I think, #3 or #4. I have to take a look at it. But retaliation has jumped up to the #1 type of category in employment. And that's concerning to us because we know that as more retaliation cases rise, the less likely people are to file complaints. So we know that retaliation serves multiple purposes when we think about discrimination. The most severe one is to let other individuals know that if you exercise your right to file a complaint, these are the actions that you could also be facing, which makes it less likely for other individuals to file a complaint of discrimination. So that is very concerning to us. So we have retaliation, you have disability, and then you have harassment that are also kind of right there along with the race component of it. Race is still in our top 5, but it has drastically dropped down below some of those other categories that we see from an employment standpoint. In reference to the gender issues, we do see some gender issues. We don't see as many as we have in past times. I would probably say, just thinking about our caseload, gender probably covers probably about 15 to 20% of the cases that we see in employment. Race carries a big part of it, but again, retaliation is carrying the day when we think about employment, which again is concerning on multiple fronts.
And retaliation is, on the national level, if you look at EEOC statistics, retaliation is #1 nationally. So it's not just a situation that's here in Maryland only, but it is a problem nationwide in terms of the category of complaints that are being filed and the percentage that is now being taken over by that particular action.
Thank you. Next, we have Delegate Kelly, followed by Delegate Morgan. Oh, no? Okay.
Thank you, Madam Chairman. And thank you both for the work you do. This was an extraordinary presentation, and I'm so impressed. Thank you. I wanted to just touch on something Glendora reminded me of, which was the legislation we passed a couple years ago related to health services and facilities and discrimination in those areas. I know you jointly share that responsibility with the Department of Health, but do you have any kind of update you can give us on that? Have you been seeing complaints in that area, and are there any trends?
Well, in terms of numbers, Mr. Horton's department would see what's being filed. I know that I had gotten a couple of calls about someone filing a complaint, and I conferred with the AG in the health department as to whether it was something that should come to us or, and I think we even had a complaint where I said, we think we need to refer this to you because this seems to be much more of a health issue than it is a discrimination issue. So I have communicated a couple of times on a couple of cases, but I don't know in terms of percentages what's coming in the door, and particularly since it's a short period of time as to whether or not there's any significant numbers.
We've only had one.
Thank you. Thank you so much. Thank you very much for that. I appreciate your
Sure.
answer.
Next, we have Delegate Taveras, followed by Delegate Hutchinson.
Thank you, Madam Chair. I just have two questions. Well, one of them is in terms of, hold on, I want to hear you better. Hold on. Okay. So, in terms of when we look at fair housing issues, particularly in senior homes, how many cases are we seeing where seniors are living with children or grandchildren that are not within the age of the individuals that are supposed to be living in those buildings?
You're talking about the 55 and older or 62 and older. One, it depends on what type of housing. If it's federal housing, then that will be governed under Title VIII. But we pretty much track what they say. 62 and over is everyone in the house has to be 62 and older. So most places, there's a temporary allowance of grandchildren visiting, staying over, but then at a certain period of time, that can continue. The right reason why is that 62 or older was designated as such because for persons who wanted to be, not to be around children. They wanted to have residents where it's simply adults in that area. And this was a compromise under the when they were passing the amendments to the Fair Housing bill on the federal level. It was a compromise because there were a lot of apartment buildings and condos that were becoming adult only, and it was impacting families with children. And so part of the compromise was to carve out when they added familiar status, was to carve out the 62 and older and the 55 and older. The 55 and older, if it's a couple, one person qualifies that. So if one person is 55, then the other person doesn't necessarily have to be 55. And then there's a percentage of the complex where 20% could be set aside for staff or instances where the qualifying spouse or partner passes away and the person that's left is not 55 would not be kicked out of their home. And so it's pretty complex, but those are the rules that are set in that exception. So, it's a narrow exception that is created for familiar status so that it was to eliminate adult-only apartments, but to provide the opportunity for persons who wanted that environment under these qualifying housing developments.
And we typically don't see a lot of those types of complaints coming through our agency. We may get maybe one or two a year, if that. When you think about our housing cases, the top protected category is disability. As it pertains to reasonable accommodation, those are the majority of the types of cases that we're seeing from a housing standpoint.
You're welcome.
Very short one.
Yep, always. Just to elaborate on Delegate Rosenberg's question, if it would be helpful to kind of get a breakdown of the 75 fair employment cases. Or have you considered proposing legislation to make resumes name blind?
We have not, that has not been, or we've seen it as an issue that we would say that there's a volume to say that this is something we need to propose legislation for. We do have breakdowns of types of complaints that we received in our annual report, the book that we provided you. It goes into employment. You said 21.
Page 21.
On page 21 is the employment section and the employment breakdown of the types of complaints we received in different categories. We try to take each of those larger, like housing, and break down, when we got significant numbers, to break down into those different actions or different areas that may be of interest. I think we even break it down in terms of what jurisdictions certain complaints are filed in. Sure, absolutely.
Thank you.
Wonderful. We have next Delegate Bandari, followed by Delegate Chisholm.
I think Delegate Chisholm was first.
Actually saw you first.
Okay, thank you.
Okay, it's the way I see it.
Okay. Okay.
Otherwise, it won't work.
Okay, thank you for the wonderful presentation and particularly this informative book. On page 29, the book highlighted significant legislation to elaborate our Vice Chair Kelly's question, that we have passed the laws to address discriminatory hiring practices, employment discrimination, hate crimes, and harassment and sexual harassment. How is the Maryland Commission on Civil Rights monitoring and ensuring the effective implementation of these laws that we passed? And what are your thoughts on their impact so far?
Well, one of the things, when I look at legislation in terms of working with proposed legislation, is to determine how can we enforce it. because there are many times there may be bills that we're trying to figure out how can that be enforced, and is there a meaningful remedy for it. So once we have the bill passed, we do, one, update the staff on the new amendments to our statute. We provide training on specifics in terms of what the new amendment brings in our enforcement, incorporate what the particular amendment provides, and in our case processing and our enforcement objectives. And we follow through in terms of educating the public, in terms with our education and outreach, to inform the public of these new changes that have occurred in our statute, and particularly if there's new rights that the citizens have. We try to disseminate that information for the citizens to be aware that they now, like for instance, source of income, we have and continue to do training and cooperation with various groups on getting the word out and determining how this is the best way to implement and execute the mandate that is given to us.
Thank you. And Delegate Chisholm, thank you for being patient. I'm so glad, it warms my heart that he has your back. Okay? Go ahead.
Thank you, Madam Chair. Yeah, I was going to thank him too for having such a keen eye on the blinking lights.
Next time I'm going to, when I see that happen, well, I saw him first, but I'm going to call on you next. We are a fair committee here.
We should do a quick one. Thank you. And thank you for the presentation.
Jeopardy.
And maybe you already answered this, but before you even brought it up, it caught my eye when I was looking through the booklet as well. But when we look at the retaliation complaints, 2018, 2019, and 2020, they're right around 300. And then in 2021 and 22, it went to above 900. And I don't know if you addressed it, or could you speculate on why it tripled over a year's period?
Yeah, so we've been seeing from a retaliation standpoint, our retaliation started to climb, to be honest, around 15 and 16, based off of where the status of our state was, our country at the time, dealing with a lot of the political rhetoric, a lot of the hate speech that was happening. We began to see a climb in retaliation. We know that around 2020, of course, we all and still are experiencing the impact of COVID-19, where employees were kind of separated. So that reduced the number of complaints that we were receiving, because if employees kind of weren't face-to-face with each other, the employee that you don't like, well, you don't have to see him, so you're not filing a complaint. After that, now employees are coming back to the workplace, so now we are seeing people being exposed to retaliatory conduct even more now, which is impacting why you see the drastic number in some of our retaliation complaints. We are seeing, some people are considering COVID-19 and some of the requirements for COVID-19 retaliatory in a sense, which is also aiding to the spike that we're seeing in some of our retaliation complaints. But again, as Glendora indicated earlier, really nationally, we're on our calls with other enforcement agencies like ours throughout the country. Everyone is beginning to see a drastic spike in retaliation since we've all tried to get back to a certain level of normalcy after COVID-19, that the retaliation complaints have just jumped and soared. Some cases doubled, in our case, to the impact that they've even tripled.
And one of the things is that persons who come and file complaints of retaliation are not aware of what in our statute and in a national level requires for retaliation. The layman's version of retaliation is not what we take, or what we can go forward with. The retaliation under the statute, under the law, requires that the person files or participates in protected activity by testifying, being a witness, and as a result of their participation or filing a complaint or raising a grievance, they are suffering an employment action as a result of that. And there's a connection between the two. That's the legal under Title 20 and under Title 7 of retaliation. However, people come, or many times retaliation is a companion issue with protected class complaint. So somebody may file a race complaint, but also retaliation will be a subset of that complaint, or a gender complaint, or a religious complaint, or retaliation may be a subset of that particular complaint. So it'll come in, and when we then investigate, we'll determine that does it meet the definition or the elements of what the law requires, or is it someone saying somebody's just mistreating me or treating me or personally mistreating me, and it's not something that we can find cause on because it's not meets the legal definition of retaliation. But it comes in the door, so we have to look.
My pleasure. Any other questions? Seeing none, I just want to thank you on behalf of the committee for coming today. Thank you for being so generous with your time and making it so clear. And I hope you get the resources you need, and if we can help, let us know. Hope you have a blessed day. For the committee, I want to thank you for being on time. If you notice, in the middle of the hearing, someone brought me the scarf. It got cold, so cold that my nose was cold. So I will ask you, for this island girl, this is too cold. I would ask you to bring your scarf so that you can stay warm, and you could probably leave it in on the chair as well, so you can be comfortable. Just a friendly reminder that tomorrow we have the bill request, that you must make the submission, the request so that you can get your bill back on time. Just a friendly reminder for that. And the other thing is that we had 18 bills that we were assigning, and a lot of you came to the office and they're all gone. So thank you for taking them. A lot of them have been already worked out. Some of them need a little work, but it's a good exercise for you. If you need any help with that, please ask any of us. We're here for you. And I want to thank Lindsay, Attorney Rowe, for putting this wonderful presentation together. It was very well done. And staff, thank you for your patience as well. I hope you have a wonderful afternoon. And we got out at 3:01. You have a great day.
Okay.